what's happening on the landscape in the state of Texas and in the Attorney General's office that y'all wanted to be working on?
We were working around the clock on COVID-related issues, and we were also preparing a major multi-state lawsuit against Google.
And is that Google lawsuit still pending?
As far as I know, it is.
But has it since been given to an outside law firm?
Yes.
At the time you were there, was it being handled in-house or by an outside law firm?
In-house.
Right. Did it remain being handled inside the firm, inside the agency, until after all of you resigned or were fired?
Objection. This witness doesn't have personal knowledge of that.
Let me put it this way. Of the people that left on the top floor that were all terminated ultimately, the 8, what people have called colloquially the 8 whistleblowers, was Google ultimately farmed out to a private law firm after all of y'all were gone?
Objection, hearsay. Objection, lack of personal knowledge.
The hearsay is
overruled.
Thank you.
I believe more than one law firm, yes.
Pardon me?
I believe more than one, yes, outside firms.
Now, the microphone, I can't tell, I don't know whether it's being picked up behind me, so if you could just, maybe, if it's louder to me, then maybe it'll be louder back there, okay? In addition to Google, were there other major pieces of litigation going on that you were responsible for?
Yes, there were.
What?
The Special Litigation Unit was very busy handling a number of election-related lawsuits.
All right. And were there other areas? What was y'all's experience or involvement at that time in trying to cope with COVID-related legal issues?
We had a section called the Disaster Counsel Advice section under the General Counsel that was handling a flood of requests from local officials as to how to handle COVID.
Well, when the Attorney General kept raising Nate Paul issues of the ones that we've gone through so far and later in the future, do you have any idea how much time or resources that were devoted to dealing with Nate Paul instead of real concerns?
We were devoting far more resources to Nate Paul than we ever should have, given the importance of those issues.
Can you put any kind of quantifying amount on it as you sit there?
Well, certainly the opinion that we discussed yesterday consumed the better part of 3 days of my time that could have been spent working on other matters. And of course, the Mitty Foundation consumed a lot more time than that.
Now, I want to ask you if I can, and then of course we haven't gotten to whatever time was expended on the hiring of somebody purportedly being a special prosecutor. In other words, the hiring of an outside counsel. We haven't even discussed that.
Objection to attorney testifying.
Excuse me, let me finish my question, please.
Judge, my objection is to the call of his question.
Counsel, let him finish.
Yes, Judge.
And then you can object. Mr. Hardin, you can finish your question.
Thank you. Do you have any idea how much more time and resources were devoted to once you discovered this issue of an outside counsel being considered and then being done?
It was many, many hours. We spent days dealing with the fallout of that, and that was all of us together. So 7, 8 of us at least, plus a few support staff. So it would be hundreds of man hours.
All right, now, Mr. Bangert, I want to go to, you mentioned what some of us colloquially have called the midnight opinion. Can you tell us, without not necessarily a long legal description, is there a section in the government code that deals with these opinions?
There is a very distinct section in the government code that deals with our authority to issue opinions, yes.
All right. So when we talk about opinions, very briefly, that come out of the Attorney General's office, how many types of opinions would you say there are involved?
There are there are a handful of types of opinions involved. The first would be an opinion issued pursuant to our government code 402 authority to issue opinions to individuals who are authorized requesters.
All right, let me stop there. So Section 402 of the government code authorizes you to produce opinions in response to whom?
Very specific individuals. There's a list in the code. chairmen of legislative committees are one, certain statewide officials. There are a handful, I believe, of local government officials who would be authorized, but it's a very distinct list, and that list cannot be waived.
And is there any distinction in the government code between an informal and a formal opinion?
No.
Do you recall whether or not in the opinion that y'all wrote at the Attorney General's request, do you recall any language at the end of it that talked about it was an informal opinion guidance? Can I put up, do we have an exhibit number for, can I step over there just to get an exhibit number, please?
Yes, sir.
Thank you. Stacy, can I ask you to put up Exhibit 115, which is in evidence? And can we go to the end of that opinion, please? But first of all, do you recognize...
Counselor, has this already on the list of admitted evidence?
This has already been admitted.
It has been. Okay.
Yes, this is one that's agreed. Thank you, Your Honor. But do you recognize this exhibit?
I do.
And what is it?
The first page, this is the opinion that we worked on and issued August 1st in response to the Attorney General's request concerning foreclosures.
All right, and this is the opinion you've talked about earlier that was completed at about 1 o'clock in the morning on that Sunday?
It is.
All right, now, if you would, Stacy, would you scroll to sort of the end of the opinion? Now, could you explain to us, I believe you just testified there's not a difference, there's not a distinction in the code between informal and formal?
And Judge, I'd object that that is an improper legal conclusion by this witness.
What? I'm
Overruled.
sorry. Thank you. This opinion that you drafted, and this is actually an opinion that you signed, correct?
Yes.
And was this division and this matter under your supervision and control?
It had been.
All right. Before you became the deputy first assistant, is that what you mean?
Yes.
Okay. All right. So the language says, I'm trying to stay with the microphone to be able to read. It says, please note, this letter is not a formal Attorney General opinion under Section 402.042 of the Texas Government Code. Rather, it is intended only to convey informal legal guidance. Explain to me what the significance of that and is that inconsistent with your previous testimony?
No, it is not.
All right, explain, please.
Well, I would analogize this to the practice in Texas courts of issuing published and unpublished opinions. We have an obligation under 402.045, which is part of the opinions authority, only to issue opinions to individuals if they are authorized requesters. You cannot simply issue opinions as the Attorney General's office to any individual who asks, because we are not a private law firm. We serve the interest of the state.
So if I walk in off the street or have something in my business or so that I really want an opinion for, am I entitled to ask the Attorney General's office to give me an opinion, just to give me the legal advice?
No, and not unless you're one of the listed statutory requesters.
Is a legislator one of those people that is authorized to ask?
Chairman, yes.
All right. And it has to be a chairman of a committee?
Yes.
And in this case, as we've talked about yesterday, that's what happened, correct?
Yes, I believe Senator Hughes at this time was chair of the State Affairs Committee and possibly one other.
All right. Now, was there a time in the history of the Attorney General's office in which the office did issue informal opinions?
My recollection was that, yes, there was a time when we would post opinions on our website that were informal in nature.
All right, and are you aware that your website, their website now, the Attorney General's website now, indicates that that stopped in 1979? Is that anywhere consistent with your understanding?
That would not surprise me.
All right. Now, go here to explain to me why you put this language in here then that said, it's not a formal Attorney General opinion. It is intended only to convey informal legal guidance. Explain why that's okay, or why you put it there either.
Yes. The normal opinions process involves going through the opinion committee. It's a very rigorous process of drafting, review, approval. It goes up through a number of different layers of review. This did not follow that normal process. It did not go out for briefing for third parties to evaluate and consider whether they wanted to brief on this. So none of those procedural aspects were associated with this opinion, nor did it receive what we call a KP number, which is a formal opinion assignment number for publication on the website and ultimately publication on Westlaw.
Well, as far as the statute is concerned, is there a distinction by what you did on this opinion that night? Any different? Is that opinion and its consequences any different than in terms of its effects on the outside world?
Objection.
Excuse me, let me finish my question. If I could remember what it was, let me start over. Is there any difference on the impact on the outside world of what you did here in this particular opinion and what an opinion that you might have issued that went through the formal process that you say takes up to 6 months or so?
No, all of our opinions have persuasive
Objection.
value.
Improper legal opinion.
Overruled. Continue.
Why did you say that then?
This signaled to the reader that this opinion had not gone through the formal, rigorous process of review by the opinion committee. It had not gone out for briefing. It had not gone through the normal process that can take up to 180 days of time. And it was also not going to be receiving a KP number. And I don't believe this is published on Westlaw. I haven't checked, but I would be surprised if it were.
So why did the two of you decide to do it this way, to put that sentence in there? Would you ordinarily have put that sentence in an opinion where, say, another chairman of another committee asked for it, et cetera? Would you have ordinarily put this sentence in there?
We would not put this sentence in an opinion that went through the normal, formal process. There were other opinions that contained this language, but all of them had similar characteristics. They were requested by someone who was an authorized requester, and they did not go through the formal process.
And does that not going through the formal process and you're communicating that to the outside world, is there a reason you do that?
This signals that it did not receive the rigorous review that an opinion of our office normally would.
So if lawyers in court are contesting having a controversial issue and their opposing side sought to introduce this, is that sort of a signal to anybody that knew about the process that they might have an argument to the judge? Wait a minute, this is not, there's no such thing, may not be such a thing as an informal opinion, Judge, but this opinion did not go through the rigorous process a normal opinion did. Would that argument be available to him?
I presume it would be. Certainly our intent was to signal this had not gone through the formal process.
All right. I notice your eyebrows go up when you're thinking. Does that mean that you never had thought about it before I just asked this?
Oh, no, this is something that we were dealing with en masse.
Objection non-responsive. There wasn't a question asked.
Okay. Were
Sustain.
you having these were you having these kind of questions all the time? Or not all the time, let me put it another way. Were you frequently having to deal with this kind of issue?
At this time, this specific moment, we were dealing with an unusual influx of requests for advice.
And was there a process in which you could provide, are there other ways that you could provide, other than just this? Could you do things in another way, like press releases or things like that?
Certainly, if we're not providing legal advice to an individual, we can send out press statements, we can send out bulletins or announcements. I don't see anything that would preclude us from doing this, but the code 402045 is very clear that if we're providing advice to an individual, then that individual must be an authorized requester for the purpose of ensuring that the interests of the state are being represented by that request.
Are you aware, one way or the other, whether opinions like this might be used by litigants in private litigation?
I assume they are, because that's why they are posted on
Objection,
Westlaw.
speculation. This witness was not there for the litigants.
I would,
Overruled.
Your Honor, I'm going to ask if the court might, I'd say this nicely, instruct counsel when he has an objection to wait until the answer is completed, and then he can object and ask for some, if the court sustains it, he can ask for other things. But this constant interrupting the witness in the middle of the statement, or the questioner in the middle of the statement, is unduly time-consuming.
Your Honor, may I respond to that?
Yes.
I have to object if the witness is testifying to things that shouldn't be admissible into evidence. I shouldn't have to wait for him to say hearsay before I make that objection. And so I would request to wait till Mr. Hardin finishes his question and then lodge my objection.
If you're talking over each other, the court reporters can't report accurately what either of you are saying, and the jurors can't hear what you are saying. So I understand, Counselor, but try to not talk over each other.
Yes, Judge.
Thank you, Your Honor. Excuse me. Now, real quickly, and we're about through with this issue, but I want to know if there are other ways that y'all chose to inform people. For instance, if mayors, what was your experience during this period of time, if mayors of cities or local government spokespersons or officers were contacting you for legal guidance? How did you approach those kind of issues in dealing with COVID?
Yes. The legislature had granted our office authority under Section 418 to respond to requests for legal advice from certain local officials, mayors are one of them, for issues related to a declared disaster in their jurisdiction. That code was passed, my understanding, in response to hurricane disasters. No one anticipated every single county in the state of Texas being placed under a simultaneous disaster declaration in response to COVID, but so it was. So we effectively became available to officials in 254 counties throughout the state of Texas under 418.
Do you have any knowledge one way or the other through discussions and activities in the Attorney General's office as to whether or not the Attorney General had indicated he was aware of other possible ways to address someone's concern about a gathering other than Section 402?
Unless there was an authorized requester under 418, no.
All right, thank you. Now, at the end of the day, once this process was completed, was there any distinction in however it would be considered by others in this opinion and the opinion that went through the very rigorous 6 months of research and consultation?
The effect is the same. They have persuasive value based on the solidness of the reasoning and based on the fact that it's issued by the Attorney General's office. It's the persuasive value of the opinion that follows it.
Thank you. Now, when we can, I want to go to one final question. Is an opinion under this Section 402 that you issued, is it considered just as authoritative, though, in terms of its results, as an opinion that goes through the rigorous examination that you described?
There's no reason it would not.
Okay. Now, would it have the same ability and the same impact if one wanted to seek to use it in litigation?
Again, the reader would evaluate it for its persuasive value, just like a formal opinion.
All right. Now, I want to move, if I may, sir, to what happens starting in your experience. When did you become, with the outside counsel, when did you become aware that the lieutenant governor wanted to appoint outside counsel?
Senator, Counselor, I almost called you Senator, so we're even.
You know, I've done it again.
Yeah. I'm going to be forced to hold you in contempt soon, Harold. Just kidding. Just kidding.
I'm just thankful I didn't put a name to it.
So am I. So go ahead.
All right, let me start again. When did you first become aware that the Attorney General was interested in and concerned and wanted an outside lawyer hired to deal with an investigation of Mr. Paul's complaints?
Objection leading.
I don't.
Overruled.
It would have been sometime in August or September that I learned about the outside counsel request.
All right, there we have seen one that talks about the matrix that such a request would have to go through. Were you aware that Mr. Vassar had drafted a contract at the request of the Attorney General's office before, and if so, when did you become aware of that?
I was aware of that, yes.
And had you taken a position about whether or not to hire an outside counsel?
With the Attorney General,
And
no.
your microphone.
I had not, but I obviously in conversations, I should say obviously, in conversations with other senior staff, we were very much in agreement this
Objection
is
to
not a proper.
hearsay. Objection to hearsay.
He hasn't. See, that's the problem with doing it. He did not talk about what they said. He did not talk about any statement. And this interruption of the question keeps it from being clear as to what he was going to say. That's my concern.
Overruled.
Thank you. So, and the question was your position.
Improper.
All right. And do you recall when's the first time you told the Attorney General that yourself?
I did not have occasion to speak with him about this as it was outside my line of authority.
All right. So if your opposition that you thought you were opposed to it, would that have been communicated to others rather than the Attorney General?
Objection hearsay.
I'm sorry, what was the answer?
I'm objecting, and I would ask for a ruling, Judge.
Counselor, you're talking over him that I can't even distinguish what you're objecting to, what he said or what he said. So let's start over on that question.
Sure. Thank you, Judge. Were your conversations, without going into what they were, about this subject with other people rather than the Attorney General?
Yes.
Objection. Okay.
Overruled.
Yes.
Thank you. Now, at the end of when did this, from your perspective, when did this issue boil over?
When you say boil over, could you be more specific?
Yeah, if you could, again, it sounded to me like you moved away from the microphone a little bit.
Mr. Bangert, you could speak a little louder, I think.
Yeah,
Speak up a little bit more.
Thank you very much. All right. I didn't know that moved. Okay.
I think I might have broken it, so
All right.
hopefully not.
So don't mess with the base of it very much or we can both get in trouble. When I used the phrase boil over, let me explain what I mean in my question. What I mean is, when did this become an issue of concern to more than just one person in the criminal justice division that you became aware of? What time frame is all I'm asking you?
Increasingly through August and into September, it became an issue of very urgent concern for me, as well as for others on the senior leadership team.
All right. Now, tell me what it was, in fact, when did this issue first surface, and what matter did it surface that gave you concern?
When you say the matter, it would be with regards to Nate Paul?
Yes.
My concerns had been growing exponentially over the 9 to 10 month period that we were dealing with matters related to Nate Paul. It began when the opinion when I was asked to intervene and work with the open records requests. It was uncharacteristic. It continued and was heightened when I was asked to work on the Mitty Foundation project. I was exceptionally concerned after the opinion was issued because I felt there had been a break in trust at that point. And of course, when I became aware that the Attorney General is now pressing for criminal investigation of individuals in the community based on allegations that all of us believed, and I certainly believed, were frivolous at best, I was exceptionally concerned.
Now, without going into what other people told you at the time in a specific conversation, did you become aware of generally the subject area or so that the Attorney General was seeking to hide outside counsel to investigate?
Yes, it involved the law enforcement action concerning Nate Paul and his properties. He was concerned that again, this was his same mantra over and over again.
When you say he, are you talking about the Attorney General?
Well, Nate Paul, and in connection with the Attorney General, arguing that law enforcement had been wronging Nate Paul, had been oppressing Nate Paul, and had been treating him unlawfully. There was no evidence that I had seen whatsoever to substantiate any of that.
Judge, I would object to that. It's an improper opinion, it's speculation, and this witness doesn't have personal knowledge of Nate Paul's opinions or feelings at that time.
He's expressing his opinion of what gave him concern on an evolutionary, evolving way, Your Honor.
Counselor, I think he's expressing his opinion, so overrule.
Yes, Judge.
Now, when exactly did you start getting involved in expressing your position and taking your position on this matter?
We were discussing it actively throughout the month of September.
All right. Now, at the time, were you aware one way or the other that Mr. Penley was refusing to sign the contract that had been drafted by Mr. Vassar to retain Mr. Kamek?
Yes.
Though it had not made its way to you, had you seen the contract that was proposed?
I do not recall, although I had certainly discussed it with others.
Did you, in fact, take any position in these meetings, you yourself, of senior staff, on the advisability of hiring Mr. Kamek to go investigate multiple public law enforcement persons? Did you?
Yes.
And what were you saying? What was your position?
Objection, hearsay.
It is not hearsay. There is no hearsay for the witness on the stand.
Overruled. Counselor, he's asking him for his opinion.
Okay.
What was your position?
There was no basis or justification for it. It would not serve the public interest.
And if you had to describe the opinion of about how many of you were involved in this issue at the senior level?
Jeff Mateer, I was aware of it. David Maxwell, Mark Penley. Ryan Vassar, obviously. Lacey Mays, because she was working with Mr. Vassar, and Blake Brickman as policy would have been involved as well.
By the way, you've essentially named the group of 8 whistleblowers, have you not?
I don't believe I named Darren McCarty.
All right, and was he one of those that was also concerned?
He was, although his focus was primarily civil.
All right, now, I don't think I asked, maybe if I did, I want to be clear. Have you sued in this case?
I have not sued the Attorney General, no.
And so as we look and listen to people in this testimony, Mr. Mateer and you both, neither one of you have sued or sought any damages or compensation. Is that correct?
I have not sued, and I am aware that Mr. Mateer has not either.
All right. Now, when how did this thing come to a crescendo, if it did? When you talk about the first week in September, what events were you aware of that affected what happened at the end of September?
I was in Atlanta, Georgia, at a conference with Mr. Mateer. We were about to join a significant telephone call with our multi-state partners to discuss the Google litigation that was planned. The call was set to begin. It was a very important call for coalition building purposes. Mr. Mateer received a telephone call. It was from the Attorney General, and I was witness to Mr. Mateer's side of the call. The call had nothing to do with Google. It was all about Nate Paul.
And at that time, how big an issue and a matter and piece of litigation was the Google case in the Attorney General's office?
It was consuming substantial resources and was a major initiative of the Attorney General's office, and it was, yes.
Did you two inform the Attorney General you were about to go into an important meeting on Google?
Yes.
What did you say?
Mr. Mateer was the one communicating directly with the Attorney General, but something to the effect of, do we have to do this now, because we're about to have this Google conversation.
What was the Attorney General's response?
I could not hear his response, but the phone call continued for some time, so I have to assume his response was yes, we have to.
All right, his objection is to you assuming, and I agree with that. Don't assume what happened, but as a result, even though the Attorney General was told that you were about to be involved in a meeting on a very major piece of civil litigation, did he terminate the call to talk later?
No, it continued for some
Objection
time.
to speculation. He couldn't hear Ken Paxton on the phone.
Counselor, he asked if he terminated the call. Continue.
Thank you.
Overruled.
Thank you. Now, this conversation that lasted, were you part of it in terms of being able to respond and hear the Attorney General?
I could not hear the Attorney General, nor could I respond to him.
Could you hear the conversation in response by Mr. Mateer?
Yes.
And the conversation lasted again about how long?
We went right up to the bell. We were almost late for the Google call. It probably took about 10 minutes.
Your Honor, I would urge that this conversation, which was happening between the two of them, is actually not hearsay in the sense the content of what the Attorney General was saying, or what Mr. Mateer was saying, rather, not offered for the truth of the matter of what he was saying about Nate Paul, but only that that's what he was telling these folks. And so I would like to tender conversations as to what he was having with Mr. Mateer as they were talking.
Hold 1 second, Counselor.
Sure.
Was there an I don't think there was an objection. You were starting this line of questioning.
Only because I didn't want to speak over anybody, but I am objecting to this line of questioning, and I do have a response if the court would care to hear it.
What is your response?
Well, that Mr. Bangert has already testified that he could not hear Ken Paxton on the other side of that phone call. So he can't testify to this court that he's adopted any of the statements made by Mr. Mateer. Mr. Hardin wants to submit Mr. Mateer's testimony. That's not made in court. That's hearsay.
If I may I ask counsel, I didn't understand the first part of it when he characterized what the testimony was.
The objection's hearsay, Judge.
Well, I understand that, but when he characterized what Mr. Mateer's testimony was, I just asked him to repeat what he said there because I just didn't get it. That's all I'm saying.
What I said was that Mr. Bangert has already testified to you and the jury, Your Honor, that he could not hear what Ken Paxton was saying on the other side of that phone call. And so there is no evidence that he adopted anything that Mr. Mateer said. And so they're not his statements, and it still amounts to whatever Jeff Mateer said is still hearsay.
I'm sorry, but you have to go back on the record. That's not my memory of Mr. Mateer's testimony. That's why I wanted to ask him to repeat it. I don't think they talked for 15 minutes with Mr. Mateer not being able to hear him.
I'm going to overrule. Be careful as you move forward.
So this conversation, did Mr. Mateer give any indication he couldn't hear the Attorney General?
It became clear to me by listening to the conversation, it was about Nate Paul, and in particular, this question about retaining outside counsel.
Objection to hearsay. Judge, may I be heard?
No, wait a minute. We just went through that. He just ruled on this matter.
I've already ruled, overruled. Continue.
Go ahead, sir.
It was concerning the hiring of outside counsel to investigate these allegations that Nate Paul had brought to our office.
Can you put a date on it?
The best I can recall, the conference took place maybe a week and a half prior to the end of September.
Was there anything in this conversation, as you heard from the other end, about him being disturbed that Mr. Pendley would not sign the contract?
Objection. The question calls for hearsay. He's asking what Jeff Mateer said on the phone call.
I believe the court's already ruled on this. I'm simply asking him about the conversation.
I've already ruled on this, Counselor.
Judge.
Go ahead, sir.
Mr. Paxton was frustrated that we were not moving forward with the retention of outside counsel. Objection
To speculation. He didn't hear Mr. Paxton on the phone call. His opinion of what Mr. Paxton thought is improper.
The court has just ruled 3 times on this issue.
My objection was different, Your Honor.
Overruled.
Now, at the end of the conversation, during the course of this conversation, were the people for the meeting at Google having to wait till the General Paxton finished trying to get you to approve an investigation by Mr. Cameron?
I know we went right up to the wire. We may have gone a few minutes past it. I don't recall, but it was close, and it might have gone over.
Well, I'm wondering, is at the end of the conversation, did you have any new instructions as to what the 2 of y'all were to do about Mr. Kamek?
I did not receive any instructions myself.
All right. As a result of that conversation, did you do anything new or express any new concern about the hiring of Mr. Kamek?
I did nothing new. My concern was heightened substantially.
Objection, non-responsive.
Let him finish the answer.
Counselor, he's answering the question that was directed.
Yes, Judge.
Overruled.
Thank you.
My concern, based on that occurrence, was substantially heightened because we were about to move into a very intense phase of the Google litigation, and the Attorney General's focus was on Nate Paul, not on the Google case.
So at the end of this conversation, who did you understand that the Attorney General wanted an outside counsel to investigate?
The law enforcement action concerning Nate Paul. That would have included the search of his house, his properties. The theory was that there had been an improper warrant obtained, and I believe there were also allegations of a conspiracy by law enforcement.
All right. And did that include investigating federal magistrates? 8 federal magistrates?
Yes.
Did it include investigating individual law enforcement officers in the FBI?
Yes.
Did it include investigating DPS officers?
I believe so. I believe that's correct.
And did you know at that time, were there any members of the Securities Board that were also part of this that he wanted investigated?
I believe Mr. Saban.
And were you aware as to what both the head of your law enforcement division and Mr. Maxwell, because I'm not sure exactly what his title is, were you aware of what their consistent position has been all along on this matter?
Yes.
And in spite of that, was the Attorney General still insisting on going and investigating these people on behalf of Mr. Paul?
Yes.
When you returned to Austin, when was the next time you had any contact or were aware of this particular activity?
I was in a meeting at the governor's office. I believe it was with Mr. Brickman. We had normal meetings scheduled during that time to respond to COVID.
Can you give us a date?
I believe this was September 30th.
All right.
Toward the very end of September. I received a text message telling me to return to the office, that something had happened. My immediate assumption was that something was Nate Paul.
Why?
Because we had been becoming increasingly concerned. We felt as if matters were coming to a head. The Attorney General was insisting that we move forward with outside counsel. We strongly resisted that. We, at that point, had become cognizant of the pattern that had developed over the preceding 9 months. And it was clear to me that hiring outside counsel to undertake this task could only benefit one person.
And I'd object to that opinion. It's an improper opinion.
It's his opinion,
That's
Counselor.
totally responsible.
Overruled.
I'm sorry, Your Honor.
Sorry. I said it's his opinion, overruled.
Yes, Judge.
Thank you. Now, when you were at the governor's office, had you been aware or made aware yet of a phone call that had been received by any of your other staff the day before involving Mr. Kamek and subpoenas?
If you're referring to a phone call received by Ms. Mays from a banker,
And I'm only asking, were you aware of that call?
The meeting at the governor's office took place on the same day that Ms. Mays received the phone call from the banker. So if that phone call took place on the 29th, that was the day of the meeting.
All right.
Objection non-responsive to the question.
Counselor, overruled.
Now, when you were at the governor's office, was there somebody else with you from your staff? Was there another member of the Attorney General's office with you?
My recollection was Blake Brickman.
All right. And were y'all on totally unrelated, normal business with the governor's office?
Normal business.
All right. So what did you do when you got that text?
Excused ourselves from the meeting, and we departed and went back to the office, the Attorney General's office.
And what time that day, on the 30th of September, did you return to the AG's office, and where did you go?
We went to the 8th floor and went directly to Mr. Mateer's office. And Mr. Mateer was there, Lacey was there, I believe others were starting to gather.
All right. And now, would you describe the atmosphere in the room? First of all, how many ultimately ended up in the room talking about this matter?
Mr. Maxwell was on vacation, but all the other deputies that were involved as the whistleblowers ultimately were there.
And what was the atmosphere?
Disbelief, shock, extreme concern.
What were you most concerned about? What did you learn that made you most concerned?
We had been following this pattern of Nate Paul and his interests metastasizing throughout the agency over a period of months. It had become clear to me, based on my conversations with the Attorney General, based on the lack of any substantiation for many of the claims that were made, based on the absence of a public interest in taking actions to benefit Nate Paul.
Non-responsive.
Based on all of those concerns,
Counselor, I'm sorry.
I
If
was
you have an
asking
objection, raise an objection, but just interrupting, not helpful. I didn't hear an objection, and I just heard interruption.
I apologize, Judge, but I'm just intending to object because I believe that what Mr. Bangert is doing on the stand is not responsive to Mr. Hardin's question, and I have to lodge my objection so that he doesn't testify before the jury.
Counsel, I think he wants you sitting so the rest of us can hear you.
Sorry, I couldn't
so we
see.
can hear you.
Just
Sorry.
please sit. We can hear you better.
I'm objecting while Mr. Bangert is speaking because he's testifying to evidence that I believe is not admissible, and he's telling it before the jury. And so I'm lodging my objection before it gets to the jurors so it doesn't affect, inadmissible evidence doesn't come in and affect their judgment in this case. So I don't mean to speak over Mr. Bangert, Your Honor, but I do have to lodge my objection on behalf of Mr. Paxton.
I just did not hear the word objection.
Okay.
And if he objects, witness, stop talking where you are. Do not continue. I overrule the objection, however.
Thank you, Judge.
And the question was, I was asking you what your concerns were, why. And I think you were in the process of setting that out. Let me ask you this. In the course of this conversation, first of all, you, of course, were not here for opening statements, were you?
No,
And you weren't here for the cross-examination of Mr. Mateer.
no.
If someone was contending that you folks were sitting around involving it in a mutiny, what would be your response to the suggestion that you folks were sitting around there cooking up a mutiny against the Attorney General of the state of Texas?
As in we were, that would make no sense to me. We were trying to protect the Attorney General as much as we could.
As a matter of fact, over the last 9 months, what had been your mission in relation to the Attorney General as it related to Mr. Paul?
We had continually, in various ways, warned him about Mr. Paul. We had discussed with him the absence for any substantiated basis for taking actions to benefit Mr. Paul. We have been rebuffed.
During all that time, were you still a supporter of the Attorney General?
Yes.
Did you believe in the things that he was publicly saying that he believed and he wanted to do?
Yes, that's why we were there.
And did you, all that period of time when you were warning him about Nate Paul, what is your testimony in terms of whether or not you still were looking after the best interest of the public, but also the Attorney General?
Senior staff always has to walk that line. And our job, we take an oath to defend the Constitution of the state, but we also are loyal to our principle. And those two things, in almost all cases, are consistent with each other. So our job is both to protect the interest of the public and to serve at the pleasure of the Attorney General.
And when this meeting is held, by the way, I think you said the 30th, and I want to sort of put a couple events in your mind to see whether it's possible that meeting would have been the 29th, for you to let us know whether it's the 29th or 30th. You ultimately called and made an appointment to visit and go to the FBI during this time frame, correct?
Yes.
And you were over at the governor's office. And if the evidence is going to be unrebutted that you and your group went to the FBI on the 30th, when would this meeting, what is your testimony as to when this meeting that you've been describing would have been?
It would have been the day before. It would have been the day before, the 29th.
Okay. So this meeting where you come back over from the governor's office and you all meet together was on the 29th of September?
Yes.
How long by this time, had you been informed of what these subpoenas that had been served by Mr. Kamek were asking for?
Initially, we were aware of a subpoena to a bank requesting records relating to Nate Paul's financial interests. That was the first one that we became aware of. We subsequently became aware of others.
Did you become aware that these subpoenas were actually seeking information through the grand jury, a criminal state grand jury, of Mr. Paul's opponents in his civil litigation?
Yes.
Objection leading. My objection is that the question is leading, Judge.
I'll put it another way, Your Honor, real
Dane,
quickly.
please rephrase.
Were you aware of one way or the other? And if so, what were you aware of in terms of whether the subpoenas of Mr. Kamek were being used and drafted to help Mr. Paul in his civil litigation?
Yes, it became, as the subpoenas began to roll in and we became aware of them, reading them, they were consistent with his argument that he wanted to pursue action against both the law enforcement officials who had pursued the subpoenas of his house and his properties, as well as financial interests related to Mitty Foundation and I believe others.
Now, at this time, when this is all happening, what was there sort of a mood of concern? When you talked about shock, why were you shocked? What were you concerned about?
We were unaware, at least I was unaware, that Mr. Kamek had been taking any action on behalf of our office. I was unaware that he had been retained. I was deeply concerned that the name and authority and power of our office had been, in my view, hijacked to serve the interests of an individual against the interest of the broader public.
And the fact that he had invoked the use of a grand jury to try to help Mr. Paul in his investigation, what level of concern and why was that a bother to you?
It was unconscionable in my view. You were using criminal process to pursue the private enemies.
Objection. I'm objecting to improper opinion about the unconscionability of these actions.
I asked why he was concerned.
Overruled.
Thank you. You can pick back up.
Yes, in my view, the criminal process had been harnessed to pursue the business enemies of an individual, Nate Paul, who also happened to be under intensive investigation by law enforcement.
So how did you folks decide? I think it was seven. Was it 7 guys and 1 woman? I mean, so when I'm talking about guys or women or whatever, how did y'all decide? I mean, what kind of considerations did you give as to courses of action you should follow?
I'll speak for myself here.
That's all I want you to do.
As a staffer, you have fidelity to the Constitution and fidelity to your principal. Those two things should always align. Unfortunately, over the previous 9 months, they have been drifting further and further apart. One always assumes the best about their principal and attempts to protect that principal's interests, even at your own expense. When I saw that the subpoenas had been issued outside of the normal process of our office to pursue criminal process against private citizens to benefit one individual, it became clear to me that there was nothing more I could do, that the Attorney General was determined to harness the power of our office
And
to fulfill the interests of a single individual against the interest of the state.
And Judge, I would object to that answer. That answer is speculation about his opinion of what the intent was of other parties.
Overruled.
Now, did y'all try to decide what to do in terms of whether you hire outside lawyers yourself? Or what kind of issues were you concerned about as a course of action going forward, you yourself?
We had stepped into the void at that point. There's no roadmap to follow when that happens.
That's sort of like what we're doing here, right?
Yes.
There's no real roadmap except for something 100 years ago and something in the 70s. You were writing on a clean slate, weren't you?
Yes, much against our will, but our hand had been forced.
So what drove you to make the decision to go to law enforcement?
In my view, there was simply nothing more we could do. The course of actions had played themselves out. The Attorney General was determined to follow this course of action in favor of Nate Paul, despite all of our efforts to persuade him otherwise. The power of our office had been fully, at that point, harnessed to advance Nate Paul's interests, and we had lost the ability to, as senior staff, protect our principal.
Mr. Bangert, there's been suggestions repeatedly in this proceeding that why didn't you just go to the Attorney General? Why didn't you go to the Attorney General, just talk to him? Did you?
Concerns were raised repeatedly and consistently by multiple members of senior staff over a course of several months. There is no question in my mind, based on my personal experience with him, that he was well aware of our objections.
And in fact, after you went to the FBI on the 30th of September, on the 1st of October, did you as a group send a text message to the Attorney General asking to meet with him?
We did.
And before that, had you been aware that he was out of town when all of this happened to begin with?
Yes.
And when I say to begin with, on the period of September the 28th, 29th, do you know where the Attorney General was?
He was on a business trip out of the state. I don't recall which state he was in, but he was out of state.
And on the 29th or 30th, were you, what was the hurry that you experienced about trying to call this to the attention of law enforcement? Were you concerned what Mr. Kamek was still serving subpoenas out there to private people, or what was your concern?
My
Objection
concern.
leading about Kamek, he's insinuating the answer in the question, Judge.
I asked what his concern was.
Okay.
Overruled.
My concern was we did not know what we did not know. We knew that he had already been serving subpoenas on banks. We were learning of additional subpoenas. In my view, we had lost our ability to speak into the situation as senior staff. We had no ability to end the use of our office to advance private personal interests, improperly using the criminal process. The only way we could deal with that situation was to make a report to the FBI. At least that was our judgment at the time.
Do you happen to recall why you picked the FBI rather than some other agency?
My recollection was that we had a relationship with some agents at the FBI who we trusted and we knew. And also the FBI, in our view, would have jurisdiction over these kinds of matters.
And in addition, DPS at that time was one of the groups, was it not, that Mr. Paul was seeking to investigate?
Yes.
At the end of the day, how long when y'all decided to go to the FBI, how many of you went and how long were the interviews?
7 of us went. We were interviewed together.
All right. And how long do you think the interview?
Multiple hours.
And once that interview was over, I mean, did you go yourself, knowing one way or the other what type of crime might or might not be involved?
I did not have the precise. I had a fairly good idea what was happening based on the evidence I had collected. Yes.
But did you, one way or the other, as a person not experienced in criminal law, did y'all sit down and decide what statute it was or anything like that?
Objection to improper opinion about what kind of crime this witness believes was committed.
That's fine. I'll withdraw that question.
Sustained.
Thank you, Your Honor. Let me ask you this. Did you consider what he had been doing on behalf of Nate Paul an abusive office?
Yes.
Objection to improper opinion. It invades the province of this jury's decision in this case.
Let me put it in.
Sustained.
Let me put it another way.
Counselor, try a little bit better.
Thank you, Your Honor. Did you yourself, when you went to the FBI, have an opinion that drove you to the FBI about what this conduct by the Attorney General did, that the Attorney General was involved in, as to whether or not he was violating the oath of office that you were familiar with and believed he should be following?
Objection to that question. Again, same objection, Judge.
Overruled.
Yes.
And what did you think? Just you personally?
Objection to improper opinion about in relevance to what this witness thought.
Overruled.
I went to the FBI because I believed that the Attorney General.
Just put the microphone up or move forward, but just move up a little bit if you don't mind.
I went to the FBI because I believed, based on my experience over the previous 9 months, that the Attorney General had abandoned his obligation to work on behalf of the interests of the people of Texas to serve the interests of one person, Nate Paul. And that was based on a series of events that occurred over several months.
Objection to non-responsive. He asked his opinion, not what he based it off of.
Sustained.
Now, after you folks went to the FBI, were you all together when you sent an email the next day to the Attorney General wanting to meet with him?
We did.
What was the Attorney General's response?
It was a very odd response.
What was it?
It was a text message saying that he would be happy to meet with us to address any concerns we may have or something to that effect.
Well, then did he agree to?
No, we did not meet with him.
How did that go? Did you know whether he was able to meet? Can I have the two exhibits? May have just a moment for Stacy. May I have just real quick?
Sure, Counselor, we're at our break time. Do you want to? I don't know how much longer you have with this witness.
I think only 5 or 10 minutes is all I have left with this witness.
Okay, we'll go about another 10 minutes.
Thank you. Stacy, can you, I believe this is in evidence, is it not? We check.
Before we put it up on the screen.
I'm told it is in evidence.
No objection, Judge, to 225.
No.
Continue.
All right. I want you to look at Exhibit 225. and explain to the jury if you can see it clearly on the screen?
Yes, I see the document.
All right. Do you recognize this document in this exchange of text messages?
It's been a while, but I recognize it.
All right. What I'm going to ask you to do, each text message identifies the sender. I'm going to ask you to publish this to the jury and the public, but keeping your voice up. It's a trick because you got to look in there. First of all, if you would, just start out with Mr. Mateer, identify the speaker, and publish this exhibit to the public.
Yes, the text message is dated September 29th, 2020. It begins at 3:02 p.m. The first text message is from Jeff Mateer to a group of us on a group text. Quote, "We have a major problem. The kid has served a subpoena on a bank. Showed up there in person at the bank." Jeff then sends a separate text with someone from World Class. And then he sends...
Did you later discover the person with him
Michael Wynn.
was Michael Wynn, Nate Paul's lawyer?
Yes, Michael Wynn.
So you have him out there serving subpoenas with the lawyer of the person that's asked for the investigation, correct?
That is correct.
Who you know is under federal investigation as you're going along.
That is correct.
Go ahead.
The next text from Jeff, "I need you guys to come back."
All right, then let's go to the next time and so.
Same day, September 29th, 2020, 9:05 p.m. Jeff Mateer writing to the group, "From Maxwell."
And what does that, do you have any idea what that's referring to? Do you remember?
I believe Maxwell had been communicating with us at that time about the events of the day and had provided his evaluation as to a letter that we had been writing.
And he was actually in Colorado on vacation, was he?
He was
not?
vacationing.
Yeah. All right, go ahead.
Then Jeff pastes in this language, "Read the letter, not sufficient. A request letter must allege specific allegations that are in violation of state law to include documentation of criminal act. The only thing you have is what happened today that is documented."
And what letter are you talking about there? Or is he talking, yeah, that you're talking about, do you recall?
My recollection is that there was a letter that had begun to be circulated amongst senior staff, but I am reaching into my memory to recall this specific time frame.
Were you at that time drafting a document to be told to be sent to either law enforcement or to the Attorney General announcing? Do you recall? If you don't recall, just tell me you don't remember.
At some point during that date or the next, I was more or less helping scriven. I was a scrivener writing up documents, including allegations concerning what had happened that day, yes.
All right, go ahead.
There's a text from someone who is unidentified. It's the person from whose phone this text was produced. It says lots of undue influence. I'm assuming that's Mr. Brickman.
All right, so now read go ahead.
I then respond, "Okay, sounds like we need to beef up the specific allegations."
Go ahead.
I then text again, "So do we need to lay out the facts that led up to today's events, KP taking NP," that would be Ken Paxton and Nate Paul, "to Moore," that would be Margaret Moore, "obtaining the referral, demanding that we investigate facially bogus charges, refusing to take our advice that there is no prosecutable offense, demanding that we hire outside counsel, overriding our advice a second time, and apparently now authorizing an improper fishing expedition by private attorneys into a civil matter."
All right, and then you have another one right after that, do you not?
I do.
Go ahead.
I then continue, "Or do we need to go further and describe the constant demands that we put the resources of the office at the service of NP's private interest," that's Nate Paul, "personally intervening in open records issues, demanding intervention in a charitable dispute over the objection of staff, demanding an informal opinion to apparently, parentheses, after the fact, benefit Nate Paul, and now finally seeking criminal investigation of federal officials involved in a criminal investigation of Nate Paul.
Keep on going.
Could you please scroll?
Down.
I then send another text. All the while over the objection of staff, its pattern and practice evidence strongly suggestive of an improper motive.
All right, let me stop you there a second. Do you believe did you believe at this time that the Attorney General that could enter into contracts, even if all members of his staff objected? Did you have any question about that in your mind?
He is the principal, and I believe he could.
All right. What was your position as to whether either ultimately, however, there might come a time where the Attorney General, in exercising what he believed he had the legal authority to do, could do something that became illegal by being used for an improper purpose? Did you have an opinion on that?
I did.
And what was it?
Yes, the Attorney General could use the lawful powers and authorities of our office for a patently improper purpose, such as using the power of our office to benefit the interests of one individual citizen at the expense of the public interest. That is improper.
If, in fact, you reach a conclusion that that has repeatedly been done, in spite of consistent advice against it by the staff, what is your opinion where there ever comes a time that staff has to complain and say, enough is enough? You can't
Objection
do
to
this
improper
anymore.
opinion.
All right.
I'm sorry, overruled. He has the opportunity to offer his opinion.
Yes, Judge.
Yes, and that is precisely what we did.
Did you consider it a mutiny?
It was not a mutiny.
How would you characterize it?
We were protecting the interest of the state, and ultimately, I believe, protecting the interest of the Attorney General, and in my view, signing our professional death warrant at the same time.
What was the stated awareness of all of you that knew the consequences of what you were doing when you staked out this position and decided to go to law enforcement?
We understood the gravity of that act. We were fully cognizant of it. It was something that we did not want to do. It was something that we tried earnestly to avoid ever having happen. But when the moment came and we realized there was no other choice, that is the duty of a public employee, to ultimately make that incredibly hard choice to serve the public interest, even at the expense of your principal, because he has insisted on an improper and, we believed, unlawful course of conduct.
Mr. Bangert, did every single one of you pay an extreme price for what you did?
Objection to improper opinion. It invades the province of the jury with regard to an article.
Sustain. Rephrase.
Bangert, what happened with you? How did you end your employment with the Attorney General's office?
I resigned from my position immediately after the 2020 election. By the time I resigned, all of my duties had been taken from me. I was simply an employee in name only.
When you, after you went to law enforcement, how do you mean your duties were taken from you?
Over the course of several weeks, I was excluded from and ultimately removed from any responsibility by the new first assistant. And then subsequent to that, in the middle of October, I was informed that I would no longer be overseeing the special litigation unit. I objected to that, and that was to no avail.
Counselor, you said about 10 minutes. For the benefit of the jury and the staff, do we want to break here, or do you need a few more
fine.
minutes?
I want to have a few minutes, but that's fine. That's
You
fine.
want to if you have a few minutes, finish with the witness. If you're going to go longer, then tell me and we'll break.
Thank you so much. I never want to be in the way of people taking a restroom break.
All right.
Thank you.
We will break until 11 o'clock sharp. That's a 20-minute break, members.
I'm just gonna